Welcome to the webinar organized by Mehta & Mehta Insolvency and Restructuring LLP. Thanks for your time. Today's we are organizing masterclass on Insolvency and Bankruptcy Code, relevant provision, case law, proposed and disciplinary order. We are covering section wise all the relevant provision, case laws, proposed amendment if any in that section, and disciplinary orders. This is our fourth session, and today's our panelist is Mr. Ravindra Bellur, Director, Bellur Resolutions Private Limited. Thank you, Mr. Ravindra. Thanks for your time. To formally introduce Mr. Ravindra is currently Director of Bellur Resolutions Private Limited, an IP based at Bangalore. His firm, company, and he currently focuses only on work related to with insolvency profession, and his firm was focusing on strategy management consulting during 2005 to 2017. He has overseen the successful resolutions, his IP entity, and he undertakes the roles of resolution professional of corporate debtor as well as personal guarantors, liquidator of corporate debtor, and bankruptcy trustee of personal guarantors to corporate. Mr. Ravindra was working in various industries for 16 years up to 2003, which included the turnaround experience in the role of CEO of polyester yarn manufacturing company in Indonesia after Southeast Asian exchange rate crisis during 97-98. Mr. Ravindra is a member of Insol International Small Practice Group Committee for the period July 25 to June 27. Mr. Ravindra is also a member of Executive Committee of Insol India for the current year. Welcome, Mr. Ravindra. Thanks a lot for your time.
Thank you very much for the opportunity. It is my pleasure to be part of this. Thank you.
Thank you. Mr. Ravindra has very vast experience and he's having various industry insolvency experience, we know. And he has done examination for Insol also, international, and he's active in that also. Thanks a lot. We have our moderator, Mr. Devang Thakkar. He's a seasoned professional with over 30 years experience in finance, secretarial compliance, and corporate legal consultancy. He holds bachelor's degree in science, followed by diploma in system management and master's financial management from NMIMS and Mumbai University. He has strong foundation for his career completed by his professional qualification, being an associate member of ICSI since 1991. He is an independent director, insolvency professional, and a registered valuer with IBBI. His extensive professional experience spans various industries such as corporate legal consultancy, financial planning, financial restructuring, and corporate legal compliance advisory. Before starting his practice, he worked with prominent companies such as Pidilite Industries Limited, Amforge Industries Limited in corporate governance and compliance. Currently, he is partner with Mehta & Mehta Insolvency and Restructuring LLP. Apart from his professional work, he is also an academic contributor, having served as a visiting faculty member at NMIMS, IES, and IBS ICFA in Mumbai, where he taught finance and business law. His expertise in financial legal matters makes him trusted advisor to organizations across different industries. Welcome, Deva. Thanks a lot for
Thank you very much for being invited.
Yeah. We thank all panelists of today's webinar for joining us on behalf of entire team of Mehta & Mehta. With this, I'll request Sakangi to start her presentation and start the sharing. Before that, Mr. Ravindra, you want to say a few words on the topic and then we can start.
Okay, thank you very much for this opportunity. The section 14 is a very, very important section. Yes, it is more so if the company which goes into CIRP is a going concern. I shall share some live challenges and connected with section 14 as we go by. I think let us start. I shall definitely share, facing in the last 1 week itself, connected with a company which is a going concern. I shall share that experience as at an appropriate time when Sakagni starts the presentation at some point of time, or if it was if that context is not right during the presentation, I will share at the end.
Thank you.
Let us. Thank you.
Thank you.
Thank you.
Okay.
Good evening, respected panelists. Now I'll be moving forward with the presentation. Section 14 of the IBC deals with moratorium. Moratorium means a legal freeze on the action against the corporate debtor so as to protect its assets and revive it without any interference. Moratorium commences the moment CIRP commences. Further, in addition to this, the 2026 amendment brought about two additions to this section. First, the insertion of subsection 2A in subsection 1, which deals with the critical service provider. And second, the insertion of an explanation to subsection 3, clause B, which deals with surety in a contract of guarantee. The same can be seen highlighted in red in the PPT. Now, to further understand the provision in a practical sense, let's dive into few cases. First, Vishnu Mittal versus Shakti Trading Company before the Supreme Court of India, order dated 17th of March 2025. In this case, the corporate debtor issued checks in favor of the respondent through its director, Vishnu Mittal, who is the applicant in the present case. However, these checks were dishonored at the time of presentation. And subsequently, this corporate debtor went into CIRP proceedings, leading to which there was invocation of moratorium and appointment of IPR. However, despite this, the respondent issued a statutory demand notice under Section 130A of the Negotiable Instrument Act against the director, following which his failure to pay led to the initiation of criminal proceedings against him before the magistrate. Aggrieved by the very proceedings, the applicant filed before the High Court under Section 482 of the CRPs, seeking quashing of the order in light of Section 14 being enforced. However, the High Court dismissed the petition while relying on a Supreme Court decision in the case of P. Mohan Raj versus Shah Brothers, stating that Section 14 only protects corporate debtor and not natural persons. Not satisfied with the decision, the applicant then further appealed to the Supreme Court. Now, the main issue in the case was firstly whether proceedings under Section 130A can be initiated against the director during CIRP. And secondly, whether the High Court was correct in its decision. The Supreme Court in this case held that proceedings under Section 138 of NI Act cannot be initiated against the director during CIRP, owing to the fact that, firstly, the cause of action arose after the commencement of moratorium. That is, the 15-day period as mentioned in the Section 138 of NI Act ceased after the commencement of moratorium. And secondly, the director was already suspended. That is, once CIRP commences, an IPR and IRP takes over the control of the corporate debtor and all the officials are suspended. Further, the Supreme Court also distinguished P. Mohan Raj case and observed that the High Court relied on the judgment without taking into consideration the factual distinction that both the cases had. In the case of P. Mohan Raj, the cause of action was prior to moratorium. Moving forward, we have the case of Asset Reconstruction Company India Limited versus Vijay Group Realty LLP before the NCLT Mumbai bench, order dated 4th July 2025. In this case, L&T Finance lent money to Vijay Group Housing, secured by its parent company, that is the respondent in the present case. Under the security, the respondent pledged 95% shareholding in the borrower company in favor of Vistara ITCL, the security trustee in the present case. The agreement had a clause, 16.2, that said that the pledge obligation would survive insolvency, winding up, or restructuring. Later, the loan was assigned to the applicant by L&T Finance and issued a recall and surface notice by the applicant. However, before the applicant was able to invoke the pledge, CIRP was initiated against the respondent and moratorium came into force. Subsequently, when the resolution plan was put forth, it included the pledged share as assets of the corporate debtor. Aggrieved by this, the applicant approached the tribunal and raised three broad issues. Firstly, whether Section 14 bars the applicant from invoking pledge during CIRP. Secondly, whether the share remains as assets of the corporate debtor. And lastly, whether Clause 16.2 was valid or not. The tribunal in this case held that Section 14.1 specifically put forth instances that are prohibited during moratorium, and as such, the applicant could not invoke the pledge during CIR. The reason is that the pledge was invoked after the commencement of CIRP, and as such, the ownership and the beneficial interest of the share continue to vest with the corporate debtor. In addition to this, the court held that Section 238 of IBC talks about the overriding effect over any inconsistent contractual instrument or agreement, and as such, Clause 16.2 could not override the period of moratorium. Moving forward, we have the case of Amazon Web Services India Private Limited versus Think and Learn Private Limited. Before the NCLT Bangalore bench, order dated 26th August 2025. In this case, the applicant provided cloud and digital infrastructure services to the respondent under the AWS agreement. And later on, when the respondent company went into CIRP, AWS continued to provide services that were essential to keep the corporate debtor as a going concern. However, the corporate debtor defaulted in the payment of invoice raised during moratorium, which resulted in AWS holding dues of about rupees 39 crore approximately. Additionally, both the interim resolution professional as well as the resolution professional recognized AWS as a critical service provider under Section 14(2)(a) and requested for the continuation of service. Subsequently, AWS filed an application under Section 60 clause, subsection 5, seeking review. The issue in this case was whether critical service provider under Section 14(2)(a) can demand repayment. The NCLT held that the applicant was entitled to payment of services rendered during CIR. The tribunal directed the RP to place the AWS invoices before the COC for payment as CIRP cost under Section 14(2)(a) read with Regulation 31 and to be given the designation for priority payment. Moving forward, we have the case of Harry Doll versus Regional Provident Fund Commissioner. Before the NCLT, order dated 18th September 2025. In this case, Global Energy Private Limited went into CIRP, furtherance of which the RP issued a public announcement inviting claims for creditors for which a last date was fixed. Herein, the EPFO failed to file for any claims within the prescribed timeline. Thereafter, in the subsistence of moratorium, the EPFO conducted an assessment proceedings and prepared a report. And owing to this very report, they filed for claims under the EPFF. However, the resolution professional rejected this claim. He stated that the claims were filed beyond the prescribed time and were based on proceedings conducted after the moratorium commenced. In the meantime, the COC also approved the resolution plan submitted by the SRA, that is the applicant in the present case. Thus, aggrieved by the rejection, the EPFO filed before the NCLT seeking consideration of its claim, wherein the NCLT awarded in favor of EPFO, directing the RP to consider the claim. Thereafter, feeling aggrieved, the SRA approached the NCLT. The issue was whether the assessment proceedings conducted by EPFO during moratorium is valid or not, and whether the NCLT was justified in its decision. The tribunal in this case held that once moratorium comes into force, EPFO cannot initiate or continue assessment proceedings against corporate debtor, owing to the fact that Section 14 creates a statutory freeze. The tribunal also clarified that NCLT was not justified in directing payment as those payments were based on an assessment that was done during moratorium, and as such, NCLT set aside the direction of the NCLT. Moving forward, we have the case of Kotak Mahindra Bank Limited versus
Mr. Ravindra, Just go back to that earlier slide.
Yes, ma'am.
Here, actually, we state that PF dues do not part of estate only.
Okay.
And these they are telling no resolution plan you should not include because they have done proceeding assessment.
Mhm.
Assessment is one thing, but otherwise also they are bound to pay organization, right?
I mean, I understand where you are coming from. That is, if the amount has been deducted and not paid, that is so. But if it is the amount is deducted and not paid, that might not be part of the assessment at all, isn't it?
Hmm.
But is it the, I mean, I have not gone through the case, but is it the amount not deducted and not paid them by them, or is it that some assessment was done on an ad hoc basis? I shall just share my experience connected with.
Ravindraji, same thing with GST. I have collected, but I've not paid because of my working capital difficulty. Same
Yeah.
logic would be here. So take
No.
some matter on that also.
No, I agree with you. But just to share one experience where we, during the CIRP and assessment was done, we took a stand that we will not admit for a specific reason. The reason was that this particular company went into CIRP and they had stopped the operations in at least 2.5 years before the commencement of CIRP, and there were really no employees, no production at a particular production facility. But this particular office made an assessment based on the earlier experience and saying that there must have been so many people, and that is why they are charging. So,
Yeah.
so in this case, there was no way we could we accepted the claim to the extent to the extent where there was an employee by employee amount deducted and not paid, but we did not admit the what you call the assessment made on an ad hoc basis. So
Yeah.
I do agree with Deepthi Mehta. If the amount was actually deducted and not entered into the EPF system, and by any chance the EPFO assessed only based on employee-wise amounts which were deducted and the salaries or the wages were paid, I think in such a scenario, that issue regarding not part of the asset, I think will definitely come into picture. I have not studied this particular case. If the assessment is based on real payment of the wages, real deduction of the wages, and not paid, I think I agree with what Deepthi Mehta ji shared, that because of the logic outside the estate, it may need to be paid. I also would draw, Devangji shared about the GST. I'll just want to tell you, connected with, I mean, not directly connected with section 14, but in some ways connected with our pains on a day to day, is that NCLT Bangalore has passed an order which said the TDS deducted some 3-4 years before the commencement of CIRP is considered that money is kept by the company like a bailey, and that money has to be paid, and our IBPI and the committee parliament, whoever represented to the parliamentary committee for the final while finalizing these amendments, they have referred this particular decision, and they are going to come out with some circular or regulation connected with this TDS. But I do agree with Devangji. If that is, we go to that extent, these monies would have been used for working capital. If we assume an extreme situation where there are no money at all, how do we pay? It is a very complex.
No, but in that scenario, when resolution plan is there, suppose GST department has not filed the claim, and even it is known that GST is not paid or TDS deducted not paid, whether resolution plan comes or not, suppose in liquidation we are bound to pay.
Correct.
We are bound to pay, no?
Yes, we are. See, if you go to the extent of this particular NCLT order, I do agree with Devangji that whatever is applicable for TDS can apply for GST also. Then,
in specific in GST case, I've already collected and not paid.
yes.
In some other cases like TDS, other things, I've not paid things and I've not deducted TDS, but it doesn't mean the book entry. So both are very different.
Yes, I agree with you. So it is we have to wait and see what amendments should come. It is not a easy situation for
that PF, GST and TDS. What should be the situation if deducted and not paid, or not deducted or collected and not paid in case of resolution plan and in case of liquidation? Yeah, there is a question.
It's complex.
Yeah, there is a question from Mr. Sandeep. Sir, 14B dues of PF are interest on delayed payment. Can this be rejected just because they were assessed during liquidation? Regular interest should ideally be allowed up to liquidation commencement date.
May I share my thoughts?
Yeah, please.
Sure, sir.
Yeah.
See, there is a bar on the assessment during CIRP. Okay. But after the CIRP, when the company goes into liquidation, in my view, there is no bar. You can accept it if it is a sensible employee by employee calculation. If it is a fact, if it is on an ad hoc basis, I don't think we can admit the claim, because ad hoc claim is there. How do you distribute among very employees? I mean, I gave an example of ad hoc claim means they have assumed that employees were working till a particular date, and they do it based on the total expenses or total sales. That is what I mean. So if the genuinely employee was working, he got the wages or salaries and it was deducted, then if only the assessment happens during liquidation, I think you don't have any what you call I understand, Nirajji. I think coming to the amendment, I think we may have one more layer. We may have one more layer. And as far as there is an NCLT decision, I don't remember the name of the decision. As far as all the three sections, which is 7A, 14B, 7Q, all have to be admitted if it is an admittable claim. That is what I know from some NCLT order. Thank you.
But there is also a question as regards what yesterday new regulation. Okay, liquidation can 7A be started if employee provident office. In liquidation can 7. In liquidation, assessment can be done. But the point what Mr. Ravindra is that this interest should be up to a liquidation commencement date. I think that is correct, right? Not after that.
Yes, exactly. It can't, the claim, whatever is there, can only be up to the date of liquidation, cannot be beyond that. But in a situation, if some employee services are continued, I mean, which is very rare, then whatever that employee is eligible and all will come into picture. But that is very rare. But the claim is only up to then it will be part of the liquidation expenses and not the part of the claim.
Yeah, and I think Mr. Neeraj will just check. Bisha, just check if we can unmute and he can speak. Then there is another question. Will ESIC also treated similar to PF claims in liquidation?
Ma'am, the point that I want to make is that we have received a circular from IBBI that during liquidation, 7A and other proceeding assessments can be done. Moratorium will not apply.
Right.
Whereas it will apply only in CIRP. Now in liquidation, I am facing a 7A ongoing case. In liquidation only they have started. So with this yesterday's amendment of moratorium, do you feel that the moratorium will apply on this and this proceedings can be stopped by this new regulation which has come? That is what I want to know.
Mr. Ravindra, you would like to comment?
See, it is a tricky
7A उन्होंने स्टार्ट किया लिक्विडेशन के दौरान, ठीक है जी. वो कहते हैं कि एंड वी हैड रिसीव्ड दिस IBBI सर्कुलर कि CIRP में नहीं कर सकते, लिक्विडेशन में असेसमेंट करेंगे. नाउ आई वांट टू नो जो कल अमेंडमेंट हुआ है उसका क्या इम्पैक्ट आएगा 7A प्रोसीडिंग्स पे, विच आर विदाउट एनी एम्प्लॉइज, वैसे ही फर्जी जैसे आप बोल रहे हो ना, ऐसे ही अनशन कर रहे हैं.
Okay. See, I just want to draw your attention. Originally when this, I don't remember the case. It is a Mumbai case. It was in 2018 September or something. Mumbai NCLT matter. I think Prakash Raj. I mean, there was one Mr. Justice B.B. Prakash was the NCLT member. I think he passed that order. I don't remember the name. The logic why the PF dues have to be out of the estate, not from the liquidation estate, was decided was it was considered, PF dues were considered as a matter of livelihood in a Supreme Court decision quite long time back, much before IBC came into picture. So, taking that cue, as Deeptiji shared, it is not from the liquidation, out of the liquidation. Two things. Number one, the meaning of the inference was drawn in that judgment and subsequent judgments that.
My question is relating to yesterday's amendment which has come on 26th. Will there is some amendment in moratorium now?
Yes, Neeraj, I am coming to that. I am coming to that only. So the logic, whatever was done in that judgment and the subsequent judgment was, once the amount becomes payable and deducted, it becomes the asset of the workman. If it becomes the asset of the workman, so the amount, whatever is the value of the liquidation estate, the value which has become the asset of the workman has to be taken away from the liquidation estate. So that was the conclusion. It said there is an asset of the workman which is in the corporate debtors asset. So to that extent, you don't touch. Now, coming to the amendment, whatever you are sharing regarding the proceedings, not to be started by or against, my thinking is like this. Let us assume the EPF dues become due only when the wages are wages have accrued, payable and paid. If whether there is an assessment or no assessment, in my view, the liquidator has a duty to pay whatever was deducted, even if there is no claim, even if the EPFO doesn't make a claim. I think these are clarified in some of the judgments. it becomes payable. If the EPFO office makes an assessment based on employee-wise calculations,
So
I
the
don't
point
think
is
that
not
was-
that. The point is whether he can make the assessment in liquidation and CIRP or not. The
that is
point is this.
no,
वो तो
I
ठीक
agree,
है,
sir.
वो तो ठीक है कि उसने अगर कटा है तो हमारी ड्यूटी है देना. देर इज ये लेबर ऑफिस का भी 10 रुपए लेबर का काटते हैं हरियाणा वाले, फरीदाबाद वाले. वी हैव टू डिपॉजिट. वी अंडरस्टैंड दैट. द पॉइंट दैट आई एम स्पेसिफिकली सेइंग इज
I am fully with you. I am fully with you. I understood your question. I am telling that whether the assessment can be done in my view, without the assessment, how the final amount can be arrived at. So, and if taking the logic that this is not part of the liquidation estate, in my view, the particular amendment, whatever you are referring, if we are not, if we go by the word, whatever you say, we cannot, they cannot do it. If we go by the spirit of the law, including the factor of livelihood, which is coming from the Supreme Court decision, I think there may not be any bar on them to make an assessment as long as it is a workman by workman, employee by employee assessment for the amount deducted and not paid. I think that
so that means that during moratorium they can do the assessment according to you, sir, and there is we are not violating the moratorium.
Just can I, Mr. Niraj, in your case, the assessment is already done when it was allowed. Amendment.
In my particular case, the company was closed in 2018 and there are no records available because those people are in jail and all that, the directors, there's nothing available. And it is written in the court order that no records are available. So on the basis of balance sheet, they are saying that job work you have done, 40% we are considering. Whereas in balance sheet, there is nothing outstanding. All PF has been paid and returns have been filed. So that is my case. But the only point that I want to know is that जो कल की अमेंडमेंट हुई है उससे क्या मुझे असेसमेंट करवानी चाहिए या मॉरिटोरियम फॉलो करना चाहिए, बस इतनी सी बात है. इन लिक्विडेशन इन CIRP I am clear they cannot do the assessment.
Yeah, they can. But in
They cannot in CIRP they cannot do the assessment. They can only ask the money which has been deducted कि भाई ये आप दे दो, ये बैलेंस शीट में आउटस्टैंडिंग है. लेकिन क्या लिक्विडेशन में कल के अमेंडमेंट के बाद मॉरिटोरियम में can they start any proceeding during liquidation or not?
In your case, assessment is already done, but you are putting other case.
No, it is not done. In liquidation only they started. After liquidation, they started this 7A, and that is all bogus, not employee wise, nothing, no amount is due as per audited balance sheet.
I think you can surely try to bring that amendment to that notice and state that you cannot do. At least to try. Of course,
then earlier we had received this circular from IBC के जो भी proceedings हैं GST की, ESI, PF, ये लिक्विडेशन में लिक्विडेटर को करवानी होती हैं, असेसमेंट्स करवाने होते हैं. So now that stands overruled by yesterday's decision, yesterday's amendment to moratorium. That is what my question is, because we are on.
It will now, because amendment will override circular. That is of course there, because this passed by that. Now circular is from IBBI. Yeah, Mr. Ravindra, you have a different view?
No, I mean, I definitely agree with you. The regulation would override the circular. But in his case, exactly the case where I have an issue.
But the same thing I was telling, in his case, assessment is already started and this amendment.
No, it has started in liquidation.
After liquidation. Yeah, of course, we are talking liquidation.
Neeraji, in my view, if it is on a if it is, I'm talking about the assessment has to be employee by employee.
No, it is not employee by employee. They are just doing ad hoc on the basis of 2018 balance sheet.
No, that in my view, such amount can never be admitted at all.
तो सर वो तो असेसमेंट कर देंगे, लड़ते रहो. व्हाट आई वांट टू नो इज कि इसमें मॉरेटोरियम लगेगा तो आईबीसी का
No, I know,
वायलेशन तो नहीं.
I understood your point, but the point is, it is the amendment is new. So if we go by the letter of the law, the assessment cannot be done. If you go by the spirit of the law, going back to the Supreme Court livelihood, it can be done. But in your case, if it is an ad hoc assessment, the benefit, even assuming that you are compelled to admit, I am talking of a very extreme this one. Even if you get an you are forced to admit also under any direction from the court. The money, if you have, even if you pay, it will not go to the purpose of the livelihood, because my employee details is not there. So that is the something. But regarding your question, it is a very interesting point you have raised. I think there will be issues like what you have raised in coming days. I think we need to wait until a proper interpretation is there. By going by the word, we agree with you.
Sir, we are here to interpret the law and reach to a logical conclusion only, sir. कोर्ट में तो टाइम लगेगा सुप्रीम कोर्ट तक जाने में. I just want to know if कल की डेट है. If I just tell him that it is in moratorium, I am not attending for henceforth. So will that suffice, or my duty is completed or not? That is what I want to know. कल की डेट है.
That is what Madam Mehtaji, Diptiji told, that if that is the word, we have to go by the word and see how it goes forward. So that is the only thing we can share at this point. I mean, my limited interpretation only to this.
You have to represent and tell that this is a new amendment has come. But they will say we have already started the assessment in liquidation before this amendment, and that's why it is not applicable. That can be their argument. Second thing is that they are telling, in addition, you also put your stand also, no, that there are no employee, how it can be paid this under IBC and all that. Then let's see both amendment and that ad hoc, the judgment is wrong.
Otherwise, should a certain amount be kept aside for this purpose till the matter is decided in future?
So the other thing is there are no assets in the company.
तो फिर क्या है?
तो सवाल ही नहीं उठता ना. कुछ है ही नहीं तो कुछ है ही नहीं.
Dissolution is pending before the NCLT.
वो तो है कि तेरी सनी कोई तेरी दशा बिगाड़ नहीं सकता, ऐसी हालत है. तो फिर ठीक है, कोई पैसा ही नहीं तो सनी क्या दशा बिगाड़ेगा. तो you just say that कि there is no money, you have done already, this amendment has come, moratorium is applicable in liquidation also, so your assessment is not proceeded. And also ad hoc assessment doesn't work, company doesn't have employee, you put all your stand and let it be. So at least your duty you have completed, but you have to attend, you can just not to attend.
पेशेंट मर गया बाद में ऑक्सीजन सिलेंडर का नहीं बनता ना.
No, just I shall share my experience connected with the actual claim they made based on this ad hoc amount. I rejected giving the same reasons. This was done during liquidation.
He mentioned his experience that he rejected ad hoc, that this is not accepted.
On an accepted.
सर वो ad hoc इसलिए जोड़ रहे हैं क्योंकि मैं उनको books नहीं दिखा पा रहा. There are no books with me.
Same issue. Okay, in our case, some books are available to prove that when it was.
I have only audited balance sheet from ROC record. That is all.
You have that proof that there are no employees during that period. That
yes, they know. It is close in stone.
So in my case, my experience is I rejected the claim and they have not appealed. They have not gone to NCLT as on appeal. Just for your information.
So he was telling that if you are forced also, you can reject that claim. But at present, of course, they are assessing you put your stand. All that.
Correct.
Thank you.
You have to attend the hearing at least.
Thank you. Nice.
Yeah, thank you. Thank you, Neeraj, for sharing your experience.
Thank you.
There is question by Sandeep ji that will ESIC also treated similar to PF claims in liquidation, that is, it remains outside estate? I don't know. ESIC, there is no decided case as such we have seen.
It's the same matter. ESI amount will be much less than the PF amount and other things.
Yeah, Devangji and Diptiji, if you go by the NCLT order, ESICs, there will be some portion of the amount deducted from the salaries or the wages of the employees, right? If my understanding is right.
Right, and it's only for a certain employee drawing a certain amount of money.
Correct.
It's a below threshold limit.
Yeah, but it is deducted, no? That
Is
See,
deducted.
once it is
it is deducted, it is out of the estate.
out of the estate. So
Once it is deducted, it is out of the estate.
same logic holds good.
Yeah.
In many cases, what happens? Employees, they deduct the amount. Employees are paid part salary, not full salary. But statutory dues, they deduct it. Employees also don't get the money. So in that case, what's the matter we have to deal with?
I think the most of these, these are all corporate debtors. Their accounting is normally on accrual basis, right? So once that entry is passed, it goes out of the estate.
Okay.
That is how I think we can interpret.
Okay. Then let's go ahead. Yeah, go ahead.
Yes, ma'am. Kotak Mahindra Bank Limited versus Hybro Foods Private Limited before the NCLT Mumbai bench, order dated 7th October 2025. In this case, the respondent had deposited a security amount with the electricity department. Later, when the respondent went into CIRP, it was found that the electricity department had raised an electricity bill of around 26 lakhs. Subsequently, despite moratorium being in force, the electricity department adjusted the security deposit against the unpaid dues. As such, the RP approached the NCLT seeking a refund of security deposit as any such adjustment during moratorium violates Section 14. The issue in this case was whether the electricity department could adjust the corporate debtor security deposit against the unpaid dues while moratorium is in force. The NCLT held that the electricity department could not adjust the security deposit during moratorium as security deposits were an asset of the corporate debtor protected under Section 14. Moving forward, we have Bildweller and others versus Joseph Welliweller and others before the NCLT Kochi bench, order dated 30th January 2026. In this case, respondent number 1 had booked an apartment, number 1C, paying the entire full consideration amount. However, the builder of the project failed to complete the project within the stipulated time, wherein the respondent filed before the Consumer Court for a refund. Additionally, he also initiated execution proceedings against it project. Meanwhile, the builder allegedly reallocated the same apartment number 1C to Mr. Siddharth. CIRP was initiated against the corporate debtor and the respondent filed for a refund claim, which was initially admitted and included in the information memorandum. However, during CIRP, the company first went into liquidation, but later a revised resolution plan was approved, wherein Mr. Siddharth was recognized as the allottee of the apartment. Despite moratorium, respondent number 1 went forward with the execution proceeding. The issue in the case was whether the order passed by the Consumer Commissioner during the substances of CIRP was valid and enforceable. In this case, the NCLT held that the attachment order passed by the Consumer Commission was legally unenforceable because it was passed during the subsistence of Section 14 of the IBC. It also relied on Section 238 of the IBC, which gives the court overriding power over any contrary laws in front of IBC. Moving forward, we have the case of Mark Infrastructure Private Limited versus NBCC India Limited and others. Before the NCLT Hyderabad bench, order dated 24th February 2026. In this case, the appellant, who is the corporate debtor, was awarded a construction contract by the respondent for the completion of the National Institute of Design campus at Vijayawada. For this, the corporate debtor furnished a performance back guarantee to the respondent, and also the respondent retained 25% from the RA bills as retentions or security money under the contract. Subsequently, CIRP against the corporate debtor commenced, and the resolution professional claimed that NBCC was holding money belonging to corporate debtor and its non-payment would affect the corporate debtor as a going concern. The issue in this case was, can NCLT during CIRP interfere in ordinary contractual commercial disputes and stop the invocation of PVG. The NCLT held that NCLT under Section 60, subsection 5, cannot interfere in contractual disputes, owing to the very fact that these disputes are ordinary commercial contractual dispute and not insolvency issues that it would be dealt with insolvency provisions. Further, invocation of the PVG is not barred by Section 14 under the IBC, owing to the fact that Section 14, subsection 3, clause B of the IBC excludes guarantees from the scope of moratorium. And the proviso to Section 3, clause 31 specifically excludes performance guarantee from the definition of security interest. Moving forward, we have the case of Ramesh Radia and others versus ICICI Bank Limited and others before the NCLT Allahabad bench, order dated 17th March 2026. In this case, the applicant booked a flat and paid the entire consideration amount, wherein it was promised that the possession would be delivered to him within 36 months with a grace period of 90 days. The corporate debtor allegedly that the applicant did not pay the amount and defaulted in it and issued a cancellation notice. However, later on in 2025, when the corporate debtor received the completion certificate, he offered the applicant the possession of the flat with a delay rebate, but the applicant did not take possession. Instead, the applicant filed a consumer complaint before the National Consumer Dispute Redressal Commission seeking a refund, and wherein the Consumer Commission ordered a refund to the deposit amount with 9% interest. Subsequently, CIRP against the corporate debtor commenced, due to which Section 14 came into effect. The applicant then approached the NCLT seeking either possession of the flat or admission of his refund claim. The issue in this case was whether the applicant, after obtaining a refund order from the Consumer Commissioner, could still seek possession of the flat. Second, whether the applicant was entitled to admission of his refund claim in CIRP, despite allegedly not filing a valid claim previously. The NCLT held that the applicant could not seek possession because he already had elected the remedy of refund before the Consumer Commission and obtained a decree. Therefore, his entitlement had crystallized into a monetary claim and not a right to possession. The tribunal further held that applicant was not entitled to admission of his claim because there was no documentary proof showing that a valid claim had been filed before the resolution profession. However, the tribunal clarified that the applicant right would be governed by the approved resolution plan, particularly exit policy meant for home buyers who had not filed claims during CIF. Moving forward, we have the case of JP Infratech Limited versus Atul Verma and others before the Supreme Court, order dated 6th April 2026. In this case, CIRP was initiated against JP Infratech Limited by NCLT and moratorium came into force. Despite moratorium, Mr. Atul Verma filed a consumer complaint before the Consumer Commission. The Commission passed an ex parte order against JP Infratech, wherein the company challenged this very order, wherein the State Commission stayed on the ex parte order and imposed a condition that JP Infratech must deposit 50% of the degradable amount. Aggrieved by this condition, JP Infratech approached the Consumer Commission through a revision petition, wherein the revision petition was dismissed and it was upheld the condition stay of the State Commission. JP Infratech then approached the High Court under Article 227 of the Constitution, wherein the High Court also upheld the previous condition. Thereafter, JP Infratech approached the Supreme Court of India. The issue in this case was whether the order passed by the Consumer Commission with a condition of 50% pre-deposit subsistence within moratorium or not. Judgment. The High Court initially was in the favor of the deposit. However, the Supreme Court of India disagreed with the entire approach. It held that CIRP against JP Infratech had already commenced and has such moratorium as in force. Therefore, the validity of the ex parte order later by the Consumer Commission itself was not valid and doubtful. The reason being that proceedings were hit by Section 14 moratorium, and Supreme Court held that JP Infratech had made out a clear case for unconditional stay. Accordingly, Supreme Court set aside the deposit condition and directed that the stay would operate unconditionally during the pendency of the matter. Moving forward, we have Gurmeet Sodhi versus State Bank of India and others before the NCLAT, order dated 8th May 2026. In this case, a consortium of banks led by State Bank of India granted financial assistance to Photos Chemical Limited, wherein the promoter and director of the company executed personal guarantees securing this entire debt. However, the company continued to default in repayment, following which the SBI classified the account as an NPA, and thereafter demand notice was sent to the company as well as the guarantor under IBC and CIRP. Subsequently, the guarantors being aggrieved challenged the order before the NCLAT issue whether the DRT recovery certificate was invalid because CIRP against the corporate debtor had already commenced and moratorium was in force. The NCLAT held that in this case, both NCLAT and NCLT have a similar judgment wherein they held that the recovery certificate was not invalid because CIRP against corporate debtor has commenced. The tribunal observed that Section 14(3)(b) of IBC expressly excludes personal guarantors from the protection of moratorium. Therefore, proceedings before the DRT and recovery certificate issued against the personal guarantors were legally maintainable even during the subsistence of CIR. Moving forward, we'll be discussing about the orders of the disciplinary committee in the month of April and May. In the case of Sushitech Industries Private Limited, order dated 2nd April 2026. The first contravention in this case was related to the resolution professional accepting and placing before the COC a resolution plan submitted by HDR Import Exports Private Limited, even though HDR had already been excluded from the final PRA list for failing to submit eligible documents within time. Despite this, the resolution professional not only accepted the delayed plan, but later allowed restructuring into an HDR consortium, which itself was not part of the final PRA list. The second contravention concerned the net worth certificate of one consortium member, wherein it lacked a date and a UDIN number. Further, even a later certificate showed substantial discrepancies in asset figure, which the RP failed to reconcile. To this, the resolution professional argued that transparency required him to place all the plans before the COC and that the COC itself chose to consider HDR's proposal, and as such, the final commercial wisdom rested with the COC. With the net worth issue, he claimed that the defects were merely mistakes or omission by the issuing chartered accountant. The disciplinary committee rejected all the submissions of the resolution professional and held that Regulation 39(1)(b) had been violated because the plan was late from an ineligible applicant and non-compliant. The RP also failed to properly inform the COC of any of these legal prohibitions. Further, the DC found that Form H certificate was also factually incorrect. And on the net worth certificate, the DC held that the RP failed to exercise adequate due diligence. And accordingly, the disciplinary committee concluded that the RP's committed serious statutory violation and suspended his registration as an insolvency professional for 3 years. The next case is of Bhashan Infotech and Infrastructure Private Limited, order dated 21st April 2026. In this case, CIRP commenced on the 4th of December 2023 and IRP was appointed. Shortly thereafter, the management challenged the admission order before the NCLAT, which directed that no further steps shall be taken. Following this, the IRP did not assume control over the company nor the management, and this entire thing continued for a period of 1 year. The contravention of this case was that the IRP violated Section 17 and 18 of the IBC by not taking custody and control of the corporate debtor despite the statutory obligation under the code exists. To this, the submission of the Indian resolution professional was, firstly, the NCLAT's order created genuine ambiguity. He pointed out that the subsequent orders of the NCLAT were also directed towards the suspended board, which created more of a confusion. Further, once the tribunal clarified about the entire situation in March, he immediately took steps to assume his charge. He also relied in the case of Ashok Kumar Tyagi, where a similar stay was put on the matter. To this, the disciplinary committee found that there was indeed an genuine ambiguity in the appellate order and held that the interim resolution professional had no malicious intent. However, he should have sought proactive clarifications from the NCLAT instead of being passive for such a long period, as something that was seen and done in the case of Ashok Kumar Tyagi. As such, a monetary penalty of ₹5 lakh was imposed on the IRP due to lack of due diligence.
1 minute.
Then-
Go to the last slide. This is, even the court is writing, seek clarification from NCLT. Though he mentioned that I am unable to do that, RPS presented, there is a totally ban from the order court, and then you say how he can take possession. He has mentioned that. Go to the earlier slide before NCLT has told. No, however, DC noted that IRP should have proactively. So go ahead where he has given the defense. The IRP himself submitted before NCLT that he was unable to take action and had not prepared the list of assets due to restraint order. अभी इससे ज़्यादा और क्या clarification मांगेगा कि मैं क्या करूँ ऐसा बोलना है? The NCLT will say what we are not RP, we will tell. Oh God.
It's heard in a hurry.
Okay, go ahead.
Yes, ma'am. The next case is of Vatva Belcon LLP, order dated 22nd April 2026. In this case, CIRP commenced on 28 July 2020. The first contravention was when Mr. Ankit Wadhwa, one of the suspended partners who was eligible to submit a resolution plan initially, was later declared a willful defaulter, which is a disqualification under Section 29A, Clause B. Despite this, he submitted a fresh plan which the resolution professional placed before the COC without informing them about the ineligibility.
1 minute. I just wanted whether that is required for that NCLT clarification is required. I think that presentation that is to be clarified actually. That was my point. Not to create anything, but I just wanted to know once he plays. So what it says that whenever it is asked, you have to say that I am unable. But if you ask, so this is the point to be noted by participant, that when you prefer before the court that you are unable, and you have to just ask the direction from the relevant court what you suggest I should do. That is the point we have to keep if you are asked that. Okay, yeah, sorry, go ahead.
Yes, ma'am. The second contravention was related to the RP's non-cooperation with the IBPI during the investigation, wherein, after repeated reminders also, the RP failed to submit information regarding due diligence undertaken under Section 29A. To this, the submission of the IRP was, firstly, the latest submission was merely a revision of the original plan, and therefore, eligibility should be tested as of the initial date. Further, he also stated that he had done his due diligence by conducting searches on various credit information platforms and that the willful defaulter declaration was not easily accessible. Secondly, he stated that all the information regarding due diligence was already there in the recall application, and as such, no separate reply was necessary. To this, the disciplinary committee disagreed and held that the November submission was effectively a fresh resolution plan because the earlier plan had never been considered by the COC. Therefore, eligibility had to be tested afresh, and by that date, the application should disqualified. Further, the DC also clarified that RP's duty of due diligence is continuous and cannot be shifted to the COC. Additionally, failure to respond to the board queries amounts to non-cooperation. As such, the DC ordered for the RP's registration to be suspended for a period of 2 years. Moving forward, we have the case of 3C Projects Private Limited, order dated 5th of May 2026. The first contravention in this case was the RP awarded a construction contract involving civil and structural work without obtaining valid approvals from the authorities, and despite court giving direction restricting such structural alteration. Next, the issue was related to the omission of site material and scrape from the information memorandum, despite the RP personally knowing about their existence, he did and later auctioning them as well. Lastly, the issue involved conflict of interest. A contractor was awarded work orders while simultaneously being connected to a consortium intending to submit a resolution plan. Further, this was not disclosed to the COC. In this case, the RP defended himself by arguing that the work was only interior finishing work. The COC had approved various commercial decisions and that he could not have anticipated the later overlap between the contractor and the resolution applicant consortium. However, the DC found that RP's defense was only partly correct and held that the RP had failed to disclose material conflict to the COC, thereby undermining transparency and level playing field between applicants. And as such, a suspension of 3 years was imposed on him. Lastly, in the case of Messrs. Indira Nagar Chit Fund, order dated 7th of May 2026. In this case, the liquidator delayed in filing both the exclusion and extension application by several months beyond the prescribed timeline. In addition to that, there was also major delays in filing the quarterly progress report and mandatory liquidation forms, with some report being filed more than 3 years later. To this, the liquidator admitted the delays and argued that he had incorrectly believed extension application should be filed after exclusion application were decided. He also claimed that he believed progress report beyond third report could not be filed until a formal extension of the liquidation period was granted. However, the DC rejected this application and held that exclusion application and extension applications are independent proceedings and could have been filed simultaneously. The DC also clarified that filing quarterly reports is a continuous statutory obligation and does not depend upon extension order. Accordingly, the DC ordered for a suspension of the liquidation registration for 3 months on the basis of consistent negligence and non-compliance. Thank you.
Thank you, dear. I think just in case of one question by Sandeep ji, in case of the ad hoc assessment claim was admitted during CIRP, can the liquidator, same as RP, still reject it in liquidation? What is the legal position?
See, during CIRP, may I? Deepti ji?
Say, in case of
No, I understood. May I respond?
Yeah,
it's
I mean, I think it is in some way straightforward because in case of CIRP, it is only collation of claim. And in case of liquidation, you can adjudicate the claim. I think that could be that is my viewpoint.
Okay. Then next is, once dissolution application is filed in NCLT and is subjudicized, do we still have to file quarterly progress report? Yeah, better we file it, and because liquidation application is there. Yeah. Your view, Mr. Ravindra?
I do agree. We have been filing till the dissolution order is passed.
When the final order comes, it's better to file it.
It is additional work, but being in this profession now, we have understood compliance work takes a lot of our time. But if you have to be in this profession, no choice.
Thank you, Neeraj ji. You have participated and raised interesting questions. Anyone has any questions, or it's time? Rightly, Sakangni has completed, even though we had a lot of discussions. He was keeping very
In the middle.
very intelligently the certain content.
No,
Thank you.
It is well done, Sakagni.
Thank you, sir.
You have taken all the cases and presented the gist and conveyed important points to make us make all
Very
of
well
us
summarized.
make all of us get updated with the matter.
Yeah.
I just shared that. I will share quickly in 1 minute.
Yeah, sure.
See the importance. it is very complicated if the CIRP is a going concern and the account has not become NPA. And there are cash credit and owed. That is what we are facing. So we have to take action as soon as the CIRP commences regarding all the credits to be transferred to a particular designated account, and also because if it is not NPA, it will be in the it will be in the regular branches who may not be aware of section 14. So
By the time it's admitted as a CRP, it's always NPA is always CRP takes 6 months to 1 year. NPA takes 2 quarters.
No, that is true. But the point is, if you get an assignment where it is into CIRP but not an NPA, it is very
rare.
Yeah, it's very rare. But I have got one such.
Oh, okay.
You are lucky.
One such, but actually speaking, they should have classified NPA for a different reason, but they may not be aware. Okay, we have a lot of difficulty in getting transfer of money from 2 banks, about 22 lakhs. We are struggling for the last 7-8 days, running pillar to post from branch to RO to MSME to NCLT, HO, MD. So I just wanted to share. You have to take action regarding transfer of money, getting the credit in those such accounts very fast. We have faced a lot of problems. That is number one. And it is interesting that it is more complicated if one of the banks declares NPA after CIRP, because we were getting the transfers from this current account, whatever was there.
Would that come in the moratorium? What's your opinion?
Moratorium is all right, sir. But moratorium with our NCLTs, we go file the application. It will take its own time.
Yeah.
So
just to understand, you got a case in CIRP where it is no NPA account. You have 2-3 bank account.
Yes.
And you have facility with one bank account and the account. Then there are 2 other bank account which has bank balance.
Yeah.
You want to transfer that bank balance to your account where the facility is there. But
where designated account is there. Yes, you are absolutely right. But in one of the banks, it was till they declared NPA, the matter was going smooth. Once declared NPA, in some of the banks, it takes, I was told that takes 1 to 2 months from if the NPA account to reach the NCLT cell. So till then, it is like a Trishanku Swarga. We are struggling. In another matter, it was a cash. This was a current account. In another matter, it was a cash credit. We gave a instruction to all the customer to transfer to the designated accounts. But in big companies, what happens is that such instructions also will take time. They transfer here, and this is a public sector bank. They debited interest. And made sure that it has it happened that it exceeded the limit. And in the meantime, 31st March means renewal has lapsed. So many reasons for them not to transfer. But finally, we could meet the topmost person who can give direction. He said, no. We should instruct all the branches that there should be not only debit freeze by the RP, the bank should credit freeze also, so that tomorrow RPs don't file a violation of moratorium.
Credit fees, what's the problem? Credit fees, what's the problem? Money is coming in.
Yeah, that is true, sir. But the money not
yet transferred
is an issue. But so they should correct the main issue. Instead of that, they want to correct some other. To reduce their
of the account only. So bloody hell, nothing.
But inflow one kar deta hai. Inflow is not happening.
I
cannot touch this account. Don't allow anyone to touch this account. Go to it. Go there.
So this is one. Another interesting in the same case is that this was a branded retail company. There is a brand agreement, no? I mean, this is an international brand agreement. As soon, see, our advocates are very smart, right? So as soon as after the CIRP commencement has happened, they are cancelling the what you call brand agreement. Is a going concern sales are happening in 10, 12 shops and all. They are cancelling the agreement. They date it one day before the order is uploaded or before the public announcement is done, and they say that they have sent before the information is known to them. So essentially, it is quite possible there may be hand of the promoter director also. We don't know what is the arrangement, but if it is not considered as a moratorium, no going concern operation can happen. So anyways, we have filed section 14, but I just wanted to share. Thank you so much
Thank you very much.
for this great opportunity, and happy to be part of Devangji and Deeptiji. So nice to be meeting like this. Thank you so much.
Thank you.
Thank you,
Thank you, Ravindra.
Very good presentation. I understand that this is a monthly series which you are doing.
Yeah.
But it takes a lot of efforts and it is very well done. And I think this is required for upgrading the knowledge for all of us. Thank you so much.
Thank you.
Thank
Thank
you.
you, Ravindra.
Thank you,
Thank you
sir.
very much.
Thank you, Sakhangi. Very
Thank
good.
you, ma'am.
Thank you, sir.
It was an honor. Thank you.